Way more better than that. And then we'll have to figure out which is those are. There's a number of devices that are. Yeah, that's.
So they also.
Yes. Yeah, that's kind of where it's
I built my house in 2017. Blue coming outside, so good. Maybe blue, hardwood on the inside.
Yes.
Being very colorful because you know, great. It's not.
So personality, not really
Personality.
Oh, really?
Not decisions. I spent 2 years in Peoria, Illinois, as a prosecutor there, and there was a defense attorney who was like 6'7", and he was like 360 pounds.
Wow.
Because when you're that tall, it's huge, so he could only get out species. And at some point, he just decided, you know what, screw it. If I'm going to be going through this, I'm just going to have fun. He would find the most ridiculous fabrics. It's made of suit.
All rise. You may be seated. Are we being recorded? Oh, in the past, there's been a red light or something. That's what- So are we ready? All right. Good morning. This is the Kansas Court of Appeals today, sitting in Topeka. It is our pleasure to be here, and we have some interesting cases on docket. So let me begin by introducing the panel. To my right is Judge Tom Malone, and to my left is Judge Catherine Gardner. My name is Kim Schroeder. We have all been on the Court of Appeals for more than 10 years. We're very experienced. I would tell you all that we have read your briefs, so you don't need to spend a lot of time involved with the facts unless it's something pertinent to your argument. And with that, we are ready to proceed. So I will call our first case. It is case number 126372, State of Kansas versus Mark Koch Sr. When you come forward, I just ask you state your name and whether you want any rebuttal time.
Kai Mann of the Appellate Defender's Office on behalf of the appellant Mark Koch. Your Honor, may I please reserve 3 minutes for rebuttal?
You may,
Thank you.
and you may proceed as you're ready.
Thank you. This case was a difficult trial full of much error, spinning the gamut, constitutional, statutory, everywhere. I only have about 15 minutes here, and if I want to try to hit all 11 issues, I'm probably already a little bit behind time. So if there's anything we don't discuss, obviously I would like to submit that on the briefing. And if this court has any particular area where we would like to start, please let me know, or else I'm just going to start from the top and try to work our way down.
Can you tell us your best argument?
Yes, I
Can
think,
you lead off with that?
yeah, I think the best argument in this case is this impacts a lot of different issues, is that a kidnapping is not a confinement plus physical injury. There has to be the intent to hold. And this issue manifests itself a lot in this issue, or in this case, where we have the insufficient evidence as to whether or not there was confinement. And even if there was confinement, was that confinement done with the intent to hold to inflict bodily injury, or whether this confinement was just inherently in beating with a close quarters beating? Because essentially a fist fight, if somebody goes down and I punch them on the ground, am I not confining them? I'm not letting them go. This is not what we normally assume is a kidnapping, because kidnapping has that element, the intent to hold.
But don't we have that if we believe the victim's testimony here?
You do have the victims, you do, but under the instructional issues, in a light most favorable to defendant, we have to look at this, and there's testimony that supports his story, which gets us to giving those instructions, which puts us in the position for the jury to determine exactly what's going on. We asked for unanimity instruction. We asked for an election on these things, and we got nothing. So to the extent that these issues are there and they're unknown, the state had an opportunity to cure, but they blocked it by fighting unanimity. They blocked it without making an election. And all these problems exist because at the end of the day, we have this kidnapping that's being charged, but there's been no explanation as to how this kidnapping is anything different than the acts alleged as the attempted murder and the aggravated battery. It's simply a fight that goes from room to room, or a struggle that goes room to room, is not a kidnapping. But that's what the state is trying to do here. Or, oh no, he's trying to confine her to kill her. Well, no. if he was trying to kill her and that's the whole thing and that's just part and parcel, unless you're doing it with a gun, bow, or, some other ranged instrument, you're going to have to confine somebody to attempt to murder them. So unless there is a confinement that is separate from, that demonstrates an intent to hold to do this. An intent to hold to do this. More of the holding has to be specifically intended to facilitate, and again, I know facilitates in the other one, try to find a better word, but to serve the actual physical contact and harm, or else you just have contact and harm that takes a while.
Why isn't that met here, though, by her testimony that she was shoved into the closet and he was trying to keep her there?
Which, again, if we're talking about issue 2 on the insufficiency, it probably does. But that issue highlights here, when dovetail was issue 3 on the general and specific, okay, well, what's the difference between the kidnapping and the battery and the murder here? Right? So if that's true, if there's sufficient evidence there, then one of these things, how are we going to distinguish those? And remember, 215109D is a conduct test, not an elements test, which is what separates it from Schoonover and was passed into law after Schoonover. It's got to mean something, and it can't mean elements. And then we get up to the lesser included with the attempted aggravated kidnapping, which would have given the jury the chance to determine whether or not there was a confinement, whether or not there was intent to hold. Again, the unanimity action, the alternative means is still available there. And that doesn't even get to the prosecutorial error, the motions in limine, cumulative error, and then the 2 issues that my client raised in his supplemental brief. So I'm saying, so even if there's enough to say, okay, just based on the sufficient evidence, this is minimally sufficient to sustain a conviction. But then when we add in all the other errors and all the other problems, okay, well, yes, there's minimally sufficient evidence, but in a fundamentally and tragically flawed trial, in which my client didn't get to present his full defense, in which his defense was predicated upon accepting responsibility for some of his actions to tell a truthful story. But then you have a detective implying that he's part of a repeat offender unit. And whether or not he did that on purpose, the detective.
Yeah, but didn't the court correct that error?
It did, but
Have that explained that he didn't become part of that unit until after this event took
right.
place?
And then right after that, you have a law enforcement witness testifying about 6455 evidence and breaking a motion and limiting. Again, this isn't some lay witness pulled off the street who doesn't know how court works, right? So if we have that, we cure it, and then we have another 455 issue right after that. I mean, I don't know how much you can say you can cure these things. And again, and then on top of everything else, on top of the prosecutorial error, on top of the instructional errors, there's just no way that this trial can be declared to be a fair trial for all the various reasons. And again, if not individually, once we lump them all together, for sure.
Talk to us about multiplicity. Go back to that, because it seems to me that each of the statutes that he was charged under required proof of different conduct.
See, here's the thing. When we talk about proof of different conduct, that's an elements test. Under 5109D, we look at what the conduct was, what charges he was charged with, and what the difference is in that conduct. And again, here, the only way these things are different is if we buy the same, they have proof of the other. Okay, but where is the proof of the confinement? Where is the proof of the intent to hold? It's not there, because really this conduct was person in a house, got scared, flight or fight kicks in, struggle, nobody got control over the other, fight ends, and it's over. There's no kidnapping there. And to the extent it is, every kidnapping was subsumed into the aggravated battery and the attempted murder, which was over when she let him out of the house. Again, there was no intent to confine here. And to the extent that the door was shut, there's been no evidence. She didn't say she didn't know how to do it. Mr. Cope specifically denied he did. Door shut, particularly when there's struggles going on, people moving, flying around, bodies going places. So for the prosecutor to say, oh, yes, no, he shut the door to confine her when there's no evidence for that, that's just a inference without a stable foundation, and frankly, contrary to all the evidence, but it goes to bolster that confinement because there is no confinement otherwise.
Well, the door was shut. They agree on that. So there was some evidence to show somebody, one of those two people shut the door, whether intentionally or not, correct?
Right. But if she doesn't know how and Mr. Koch intentionally does it, I don't think it's a fair argument to say, oh, well, no, he intentionally did that on purpose. I think that's too far of extrapolation.
Play inference?
No, I do not. Unless there's some other inference to stack there. The door shut. Yes, he could have shut it. She could have shut it.
We're talking about the door to the bedroom.
Right. But I'm talking about the intent because the prosecutor's argument was, I got, no, he just shut the door. It accidentally happened. Door shut. It's probably his fault. Like, no, he intentionally shut the door to do this. No evidence whatsoever on there. And again, if he did shut the door to do this, why did he need help to get out? Wouldn't he know where that door was when he shut it? Wouldn't he not need his victim to let him out of that door? I mean, there's just not a lot here that makes sense, but it only makes sense if you're bound and determined to get a kidnapping from this set of facts where there is no kidnapping. You're just not, because there is no specific intent to hold to do one of the targeted outcomes of the kidnapping statute. Now, again, harm happened. We're not disputing that, right? We're not trying to make light of the injuries Ms. Ambar suffered. But at the end of the day, there was no specific plan to go in there to confine her to do these things. These things just happened when my client thought he was burgling an empty house. That is just not a kidnapping. It's just not. It's unfortunate, but it's not a kidnapping. So, I really don't have anything else planned. I really didn't have that much planned. I was kind of hoping to talk it out, and so I appreciate all your questions. But unless there are any other questions, I'll sit down and wait for rebuttal.
Not at this point.
All right, thank you.
Good morning. May it please the courts? Oh,
There we go.
good morning. May it please the
Take
court?
advantage of all this technology.
Absolutely. David Loudon, Deputy Riley County Attorney, appearing on behalf of the state of Kansas. Like Mr. Tate Mann, I would largely submit this case on the briefing. I think it's been extensively briefed, but I will address some of these issues that he has talked about. The overarching issue on his claim about the aggravated kidnapping is his disagreement and trial counsel's disagreement that the Bugs test applied to this situation where instead of the element of facilitation that we were, it was addressed under the element of with the intent to hold, to injure, or terrorize. Clearly, the Kansas Supreme Court has already addressed this issue. And I know Mr. Tate Mann is indicating, you know, this is not about necessarily about that part, but the statute 215109 that somehow changes the calculus here. But to be clear, this court has no ability under Kansas law to make a ruling contrary to what the Supreme Court has already said regarding the Bugs, Burden, Butler cases. To the extent that we're talking about 215109, I think it's important to look at what the statute actually says. As indicated in my brief, he's trying to take 215109D in isolation, and it doesn't really apply. 215109D prohibits convictions for general and a specific crime that are based on the same conduct. 215109A states that when the same conduct of a defendant may establish the commission of more than one crime under the laws of the state, the defendant may be prosecuted for each of the crimes. So to the extent that the argument is somehow we can't charge more than one crime based on the same conduct, that's clearly refuted. The only way that this argument by the defense can succeed is if there is a showing that there is a general and a specific intent crime a specific crime, I'm sorry, a general and a specific crime. And notably, he's talking about the crimes of aggravated battery, attempted second-degree murder, and the kidnapping. As I've argued in the brief, I don't see how there's been a showing that any one of these crimes is a general crime versus a specific crime with regard to each other.
Could you give us an example of when that would be? When would the statute apply? What type of crimes would that be?
Goodness. The general crime of, I think we've dealt with this kind of in a situation where you have possession of a drug or something of that nature versus possession of a specific. I think they've applied it. The courts have applied it to situations involving tax stamps, for instance. And Mr. Tate Mann is saying that this isn't necessarily a issue involving identical offense doctrine, because he wants it to go beyond that with regard to the actual convictions. And that's why in my brief, I'm saying, we have a disagreement that he's claiming he can raise this issue under an illegal sentence issue. And I'm saying he's not doing it because what he wants to do is eradicate or remove 2 of the convictions and only have 1 standing. But this is not a situation where there's a general and specific. They don't match up. As you noted, Judge, the elements aren't even the same. And he's arguing, well, we're not talking about an elements test. Well, that's fine. But in order to determine what's a general crime and a specific crime, you actually have to look at the elements. And these crimes are not related to one another. They're all separate crimes. Under 5109A, they can be charged because they are not the same crime. As far as the argument regarding the intent to hold, I think it's already been pointed out, there is evidence of intent to hold and his intent to injure and terrorize her. When first encountered in the house, rather than run from the house, Mr. Koch decided to not only batter this victim, but he also pushed her into her bedroom, pushed her into a closet, and then he didn't leave. He continued to attack her and hold her. Presumably, they entered the bedroom through an open door. Otherwise, they wouldn't have gotten in the bedroom. That bedroom door got shut. Our victim indicated that she did not shut the bedroom door. The only other inference that could be made is that he shut it. It's a reasonable inference. So that evidence.
But didn't the victim just testify that she didn't recall how the door was shut?
I think it went beyond that, Judge. I could be wrong, but I'll let the record speak for itself. Even as such, his argument that there is no evidence of intent to hold, to terrorize, falls short when we talk about the evidence that has been presented in this case. As far as, I did want to bring up a couple issues here. As far as the multiple acts argument is concerned, I think Kansas law clearly indicates that multiple crimes supporting the crime of burglary with those underlying crimes that he has to enter with or remain with the intent to do those crimes. Those clearly are not multiple acts under Kansas law. Our Supreme Court has indicated those are alternative means of committing a crime. When Mr. Tate Mann indicates that there was some kind of error regarding how the instructions were given and what he was entitled to, and creating this web of error, I think it falls short when we look at what the Kansas Supreme Court has indicated that we must do when we're looking at instructions, multiple acts, as far as multiple underlying felonies for burglary. The same would occur as far as
On the aggravated burglary instruction, to the extent that it says that he remained in the property with the intent to commit an attempted murder in the second degree, you can see that's problematic, right? You're just saying it's not clear error because there's also the option of the intent to commit an aggravated battery.
In part, yes, Judge. It is unfortunate that they left that as with the intent to commit an attempted murder. That is unfortunate. My argument with regard to that is twofold. One, instructional error can be harmless or subject to clear error, either way. Given the fact that the jury found Mr. Cope guilty of second-degree murder, the inclusion of that attempted murder portion in there, if it had been properly instructed as just second-degree murder, the outcome would have been the same had the instruction not contained that error. The second part of my argument is that there is a second crime in there that was also, they found guilty of that crime. So the outcome of the case would have been the same with regard to that as well. Did I answer your question? Unless this court has any other questions, the state requests that you affirm the convictions, affirm the sentence, and deny relief.
Could you talk to us a little bit about the lack of an instruction on the attempted kidnapping as a lesser included offense? Which was in the briefs, but I don't think counsel mentioned it.
He didn't. I think the position of the defense is that there was adequate evidence to give that instruction. The argument in my brief is that given the evidence presented, the instruction was not factually appropriate. I cite to the Pham case in there, and it indicates, given the circumstance that we have here with the facts we have here, there was no attempted kidnapping in this case, and that's why the instruction was not given. To the extent that this court disagrees with that, again, this goes to, whether a reversal is required. Reversal would not be required because there's adequate evidence to support the notion that had the instruction been given, the outcome in this case would be the same. Did that answer your question?
Thank you.
Okay. If there are no other questions, the state rests. Thank you.
Thank you. Mr. Mann?
Thank you, Your Honor. I want to pick back up on the unanimity, difficult word to say, unanimity discussion. First off, this particular brand of unanimity, where there is a legally inappropriate alternative means, can't be harmless. That's what Griffin says. That's what Carr says explaining Griffin. I know that they cite it differently in their brief, but my reply brief, I put the actual quote in there, is that an illegal alternative means cannot be harmless. And they explain this in Griffin and Turner and the other United States Supreme Court cases, because when you have a factually inappropriate alternative means, well, that's fine and that can be subject to harmless because jurors are really good at determining what's factually established and not. That's their whole job. They know nothing about what is legally appropriate and it's not. And in this case, where the state had the objection, had the ability to make an election, was on notice of this problem, it's just inexcusable for this to happen when they had so much notice. Secondly, even if we move beyond the United States Constitution, I still believe that we get into Kansas constitutional errors, and I look forward in this case to hopefully finding out what the standard for Kansas constitutional violations are. As I briefed in my brief, I don't think there is one because our section 18 grants a positive right to a remedy. A conviction under these circumstances is certainly an injury to reputation person and messes with Mr. Koch's ability to gain property for sure. It's tough to do in prison. So section 18 demands a remedy here. And I understand. I get it. Criminal defendants are entitled to a fair trial and not a perfect trial, right? But my question is where did we come to a point where a trial that just doesn't violate the Constitution, not the statutes and all the procedure we've built up to enforce the Constitution, but just doesn't violate the Constitution, why does that count as a perfect trial? Shouldn't that be the bare minimum? And this idea of constitutional harmless error didn't arise until the 60s with Chapman. And if you look back, I understand in Gleason they cite cases, but one, none of the cases the Kansas Supreme Court cited in Gleason for harmlessness of the Kansas Constitution actually discuss the Kansas Constitution. And two, once you actually do find founding era cases that discuss the Kansas Constitution, when there's violations, there's no discussion of harmlessness. I can supplementally brief those for you later. I've done those in other cases, but violations of Kansas Constitution can't be harmless. And constitutional harmless error is really a very slow accretion and loss of our constitutional rights on a case-by-case basis.
Carr doesn't say that it cannot be harmless, correct? It says use the constitutional harmless error test.
And I think that's wrong once you look to Griffin. Because again, Griffin says if it's an illegal means, it's automatically reversible. If it's a factually unsupported means, that can be subject to harmlessness.
Aren't we bound by Carr?
I think no, because they messed up Griffin, and that's interpreting Griffin. You're bound by the United States Supreme Court on the United States Constitution. Kansas Supreme Court hasn't said anything about the Kansas Constitution on this issue.
How does the Kansas Constitution differ from the federal Constitution such that it would warrant a different result here?
We are granted a positive right to remedy via Section 18. We are granted extra due process rights that aren't involved in the United States Constitution because the Kansas Constitution has the rights to equal protection, has the rights to due process, which again provided this positive right to remedy, which there are no positive rights in the Kansas Constitution. But most importantly, our Constitution was made before the 14th Amendment. None of our jurisprudence was made to comply with federal ideas of due process because federal ideas of due process didn't apply to the states at the time. And anything, the Kansas Constitution and Kansas as a state is a rejection of the lack of rights extended by the federal government, leading us to go to war and claim ourselves free state. It is an expansion of human rights. And so to look at the Kansas Constitution and think about, oh, well, I don't know what Thomas Jefferson said. Well, yeah, no kidding. He was dead. We had moved from Locke to transcendentalism. America had changed a lot. Those ideas have changed a lot. And the Kansas Constitution deserves the respect of its own document and not to be overshadowed by the federal document because they were never intended to be overshadowed by it. The Kansas Constitution is a document in defiance of the federal Constitution to provide more rights.
But when you look at the specific language in our Constitution, is there a particular clause or article in there that you would say is different than the federal in this case, which would compel us to use a different?
Yeah, absolutely.
standard?
Section 18. Section 18 offers a positive right to remedy. The difference between a positive right and a negative right. Negative right. No one can take my pen, okay? No one can come and take my pen. I don't have to do anything. I just got to stop people from doing it. Now, positive right. Everybody gets a pen. Well, now I have to go provide pens for everybody in this room to fulfill with that right. When we're talking about rights to remedy, our constitutional rights, fundamental constitutional rights in the foundational document, we're not talking about statutory error here. These rights were violated and taken from him. This denied him his fair trial. Under Section 18 of the Kansas Constitution, the government has to provide the positive rights and the remedy. So here, Mr. Koch is entitled to a constitutionally sufficient trial. It's not as high a bar as it sounds, but that's what the Kansas Constitution demands. And there is I don't have the case on me, but I can file it later. Early in statehood, our Supreme Court recognized that our notions of due process were different than federal and any other type of treatise that couldn't be applied because of Section 18 and our special due process right.
Thank you.
Thank you.
Thank you. Thank you, counsel. We'll take the matter under advisement and we will render an opinion as quickly as time allows, generally within 60 days. Thank you. Our next case this morning is the estate of Robin Keebler by and through its duly appointed administrator, Cynthia Coleman, and Cynthia Coleman, heir at law of Robin Keeler, deceased, versus the Kansas Village at Old Town LLC, case number 128715. Counsel, as you come forward, please announce your name.
Melinda Young on behalf of the appellant, the estate of Robin Cooper.
Wes Smith and Olivia Rochelle on behalf of Appali, Kansas Village at Old Town.
And will both of you be argued? Or just, okay, thank you.
But my associate had ample work on the brief, so.
Well, that's fine. I just wanted to know from my records
Yes,
if you were splitting time.
thank you.
So I think we're ready to proceed. And I have this down for 15 minutes on each side. Are you requesting rebuttal?
Yes, Your Honor, I would request 3 minutes rebuttal.
And you may proceed.
Thank you. May it please the court. This appeal presents 2 questions. First, whether the district court in this case erred in holding that the landlord, KVOT, owed no duty to protect its tenant, Robin Kubler, solely because she was struck by a car in a public alleyway, when the Kansas Supreme Court precedent in Hammond versus San Lolete VFW post establishes that a property owner is liable for foreseeable injuries when the duty arises and the breach of that duty occurs on the property, even if the physical harm occurs outside the property boundaries. The second issue is whether the district court erred in determining as a matter of law that harm to a tenant from criminal acts of third parties was not foreseeable, despite disputed material facts showing that a reasonable person might conclude the harm was foreseeable under the totality of circumstances test. The district court granted summary judgment on both grounds, and both determinations were legal error requiring reversal. On the first issue, Hammond controls the property line issue.
Let's say that we agree with you with that.
Okay.
So what is the breach that arose on the property here?
The breach is the landlord's failure to provide some degree of protection or security from the criminal acts of third parties, which is required of a property owner when criminal acts are foreseeable.
Are you saying we should use general proprietor standards that were at issue in the Hammond case here in a landlord-tenant dispute?
Well, the Kansas courts have also applied a landlord, or has also found that a landlord has a duty to provide a degree of security for foreseeable criminal acts of third parties to its tenants. And so the issue in Hammond that's applicable here is with respect to a property owner and the fact that the duty and the breach arose on the property, but the injury occurred just over the property line. If we didn't.
Go ahead. No, go ahead.
If we didn't apply the Hammond standard, even in a landlord-tenant situation, it would result in a world in which a landlord could allow a gunfight, a foreseeable gunfight on its property. And when a bullet is fired and the stray bullet hits a child tenant who's playing on the property, but just at that moment has stepped across the property line. If we didn't apply Hammond in that situation, then that would be okay, just simply because the child tenant stepped over the property line when the bullet actually struck them. Or in Narrow, I think the issue, the court found that the landlord did have an obligation to provide protection to the tenant from the rape committed by another tenant. And but if we didn't, in that type of scenario, if the rapist, the foreseeable rapist, had lured the tenant into a security or a supply closet or something that wasn't a common area, the issue is really, and what the court has already found in that case, was that the issue was that there was a duty that arose and a breach of that duty prior to that rape occurring, whether it occurred in the common area or the.
In Nero, though, I mean, the dorm had actual knowledge. This guy was accused of rape before, and he raped a gal in the common area. And in Hammond, I mean, the barkeeper or the landlord, not the landlord, the proprietor had actual knowledge of this fight, and they took the duty to escort the guy outside, knowing that this was a likely result. What comparable acts were there here by the defendant?
The acts by the defendant here, kind of, in my mind, I see them in two different categories, if you will. One before the day this happened, and one the day that this happened. Before the day that this happened, we know that this was a high crime area. We know that there were several incidents, criminal incidents on the property in the couple of years prior to this incident happening, many which involved domestic disputes and disputes amongst tenants or involving tenants that occurred on the property. And we also know that the security manager or the manager of the property had requested from the owner, the landlord, more funds or more security because of the concern of the criminal activity on the property, which makes a criminal act of a third party on the property foreseeable to this landlord.
If it had similar harmful conduct, correct? I mean, don't we apply that test when you're talking about the totality of the circumstances? I mean, you're talking about foreseeability that ties into duty.
Yes.
What similar conduct was the landlord put on notice of?
The similar conduct was all these prior incidents of domestic disputes or disputes amongst tenants that were occurring on the property. Now, the district court focused improperly on the vehicular homicide or the hit and run aspect of this, and said there's no, it wasn't foreseeable that a tenant would be the victim of a hit and run or vehicular homicide. But that is way too narrow under Kansas law. The question is whether there was the specific type of injury or mechanism of injury isn't what is looked at. What is considered is whether there is whether it's foreseeable that a tenant, given these circumstances of other tenants or individuals fighting on the property, would cause, or whether it was foreseeable that an injury would occur to a tenant, whether it was a car or a stray bullet. The specific mechanism of injury is not what is considered in determining foreseeability.
But under Siebert, we have to, under the totality of the circumstances, show that the circumstances have a direct relationship to the harm incurred. Do you meet that test here?
Yes, because of the fact that there are repeated incidents prior of tenants or disputes involving tenants, domestic and otherwise, occurring on the property.
But this dispute, the person driving the car wasn't a tenant.
Correct. The dispute involved a tenant and her boyfriend. And then, yes, the person driving the car is another person that joins this dispute and becomes involved in this dispute.
So how is it foreseeable for the landlord to know that a non-tenant might run over a tenant in the public alleyway?
The question really is, under Kansas law, is whether it's foreseeable that these disputes amongst or involving tenants or disputes and criminal acts on the property are likely to cause harm to the tenant. And not so narrow as whether someone's going to, run over another tenant. I mean, that might be a situation that in and of itself is foreseeable, but just the fact that that there were repeated domestic disputes, it could be, again, a fire, or a gunfight. Somebody, Miss Nolte could have shown up with a gun and not hit Robin Kubler with her car as she drove away, but instead tried to shoot the boyfriend and hit Miss Kubler in the process. What is foreseeable are these prior disputes, fights on the property that the landlord wasn't doing anything about to break those up and move people along.
Could you shift a little and talk about the second part, which is what happened that day? What notice did they have? How long did it go on? How many people were involved? What happened? What does the record prove?
Yeah, so yes, the other issue is, even if you disregard everything that happened before that day, the events of that day alone are such that this landlord should have known and could have taken action to break up this fight on its property and moved people along.
So no actual knowledge is alleged.
Well, it is alleged, but even if you disregard everything else and say that this one day,
That's what I mean, actual knowledge of this fight on this day by the defendant.
yeah, as far as I
Is there
understand,
evidence of that?
in the record, we don't have the manager saying, I saw this fight outside and didn't do anything about it. But the length of time that it went on.
How long was that?
Well, we know that the fight between the tenant and her boyfriend went on all day long. Now, he left and would come back and left the
You
property.
mean in their apartment?
Yes, I believe so. But the dispute that occurred there in the parking lot, in fact, I was trying to find that exact timing. I don't know exactly the amount of time, but what I do know is that from the time that this dispute started, we have a dispute occurring in the parking lot. Then we have the tenant calling her friend, Miss Nolte. She drives over from some other location. She then gets in a fight with the boyfriend. She pulls into the parking lot or a parking stall, has a fight with the boyfriend.
Verbally?
Yes. And in the process of fighting with the boyfriend, she hits Miss Kubler's car.
With her car?
With her car. Another tenant who's just observing this dispute goes to Miss Kubler's apartment, because this person apparently knows this is Robin's car, goes to Robin's apartment, tells her what's happened. She goes out to investigate. So we know that it went on for a period of time. We know that it involved, the reports of law enforcement document multiple people, more than just the 3 individuals that were involved, multiple people, I know of at least 7 by the time the record establishes, at least 7 by the time Miss Nolte runs over Robin.
Is she alone in the car driving, Miss Nolte?
Yes, I believe so. Yeah. And
7 people had done what?
were in the parking lot observing this dispute when this happened. And I believe the record shows that the manager's office is directly across the street. This is a property that has an apartment complex, and then it's separated by, or it has multiple buildings that are separated by city streets. But the particular manager is right across the street, I believe.
So no representatives or anybody, security, any employee of the manager was one of those 7 people?
Correct. That's my understanding.
Okay.
Yeah. Yeah. I think I'm out of time. So unless there's.
Thank you. We'll still give you your 3 minutes.
Okay, thank you.
May it please the court, Appellee Kansas Village at Old Town asked that the decision be affirmed for 2 reasons. Namely, that there's no duty owed to Ms. Kubler to protect her over a public alley over which it doesn't have any control, right? Control is one of the first elements that we need to talk about. Additionally, there's no duty under Kansas law to protect individuals from a random hit and run by a third person. So foreseeability, which we already talked about, that's the other element that's lacking here to establish liability on my client. I want to back up just a little bit before we hit those issues and talk about some of the issues that were touched on by appellant here, namely what type of law that are we trying to apply? Specifically, this is a landlord-tenant dispute. That's the nature of the relationship involved. There is no special relationship alleged between Kansas Village at Old Town and the perpetrator of the crime.
Why wouldn't the Hammond rule apply here, though? Does
Well-
that make sense? I mean, if you have somebody on your property, you know that that you have a duty to use reasonable care to protect them, and there's a duty and a breach of duty. I mean, you see something happening and they step outside the premises. Why
Well,
should they be absolved of liability just because of that fine dividing line?
multiple reasons. First of which is control, and I'll get to that in a second. But specifically here, Hammond talked about imposing liability and premised on Section 344 of the restatement, which specifically talks about a proprietor of a business who's open to the public and has business invitees in, owes a duty of reasonable care to those people he invites on, the business invitees, right? That's the basis for liability there. And in Hammond, well, first of all, let me tell you, 344 says that it subjects these possessors of land, of which the landlord is not. They don't possess the apartment nor the parking space that Ms. Kubler has. But the possessor of land is subject to liability to members of the public when they are upon the land for such a purpose for the business itself. And if you look at the comment under the restatement, it says, this section is only when he holds the land open to the public for entry to his business purposes, and then only to those who come upon the land for purposes for which it is thus held open to the public. So this is your typical restaurant, your tavern, your Hammond case, where you are holding it open to the public and managing and maintaining control over the premises for that purpose. And that's what we see in Hammond, where we have specifically a bar manager who not only was aware that there was a fight brewing, right, had knowledge that the person who attacked the plaintiff in that case had previously been banned from the bar. So they established control over the premises, right? They had exerted that control over the perpetrator in that case by previously banning them. And then kind of, if you read between the lines, it looks like they acted in collusion with that the perpetrator in that case, where the perpetrator comes up, tells the manager, hey, kick out this out-of-towner, follows him out, jeering. The manager's there as he's pushing him, the attacker is pushing him up against the wall. And it's alleged that that act of negligence, i.e. kicking them out of the bar, throwing them to the pack of wolves, so to speak, is actionable under law, just because the act itself occurred in and on the premises for which they control. That's not our case, right? DWB Bliss is another one of these that talks about landlord-tenant or conflating property cases with this special relationship and control over those with dangerous propensities. And they emphasize that the prevailing rule in Kansas that the absence of a special relationship, there is no duty of an actor to control or the conduct of a third person to prevent harm to another. And they specifically warned against stretching restatement provisions to fit the facts of a case. right? They said in that case it was suing a wife for the alleged sexual misconduct and assaults of her husband because she was a co-owner of the property where some of those may have occurred, the home, right? And she had control over the property. And it says it's not logical to create liability when clearly distinguishable facts are only close to what is necessary to establish a special relationship. We have, in all our special relationship duty cases, followed the outlines of the restatement. And to judicially create responsibility based on the marriage between would create a slippery slope of untenable property, so to speak. Now, what is the nature of the relationship here in this case? It's a lease. You have it, right? This is not a proprietor case where you don't have a contractual relationship with the injured party. You specifically have a relationship here, and it defines the terms of that relationship. And those terms of the relationship specifically speak to the fact that there's no representations. You can look at it, it's page 4 of or 54 of volume 1. Resident occupants acknowledge that neither their owner or management has made any representations, written or oral, concerning the safety of the community or effectiveness of operability of any security devices or security measures. And there's no warranty or guarantee, and residents and occupants acknowledge that neither the owner nor the management warrants or guarantees the safety or security of resident occupants, their guests, or invitees. That's the nature of the relationship. And if you look to the South v. McCarter case, that's specifically the most case we have on point here. It is a mobile home park. So you have leasees, so to speak, who have a specific property. And in that case, there were a fight between boys. One had their jaw broken. There were specifically allegations that they were aware that one of the boys in the fight had previously engaged in such fighting behavior, although it was 2 years previous. So specific knowledge of the actor in that case. And the court said not foreseeable enough. But the control issue was present there because the terms of the lease, which the court dove into in significant detail, specifically articulated that the landlord reserved control over the common areas where the fight occurred and had a duty to maintain those to their tenants. That's not our case. We're even one step removed from South, where the summary judgment was upheld there because there is no control at all over the public alleyway. We just heard a case, I don't know the facts of the case, but we just heard that a case about kidnapping. And, you know, if a security guard were to lock Ms. Kubler in her room, we would be talking about that as opposed to failing to provide security. They have no ability or legal right to keep her in her room when she hears a fight breaking out in an alleyway, nor do they have any right, anybody, to keep her from entering that alleyway and stay on the property either. There's no legal right. There's no even effective ability to do so. So that control.
Go ahead.
Oh, no, I'm sorry. Go ahead.
Well, what about more generally? I mean, was there a security guard? This is alleged to be a very high crime area in Topeka, and it very well may be. I mean, what about just general duty to provide safety and take reasonable precautions as a landlord for your tenants?
That is specifically can be contracted for. So the South case talks to this that, and specifically DWV Bliss says, okay, people are not dangerous conditions of property, right? That's this takeaway from there. But you can lease for more than just property. You can lease for services too. It's a package of goods, so to speak. And South speaks to that. And specifically where you have representations made that, hey, we are going to provide security, that we have, you know, a guard on duty from X hour to Y hour, and that is relied upon by tenants, then that can be actionable for failing to uphold the terms of the lease or the terms of the agreement by giving that expectation to the tenants. That's why they talked about the terms of the lease in South specifically. And that's why they focused on that. And that's specifically distinguishable here where we don't have those terms. We have the exact opposite. We have a contractual provision that there are no guarantees made one way or the other. Now, there was reference to concerns from the security manager there. There are a host of evidentiary issues on summary judgment that I cannot overlook and that the court of Judge Christopher did well to sort through. But I do not think there's adequate evidence of any type of security concerns from the manager one way or the other. The only evidence cited in support of that is an affidavit, single affidavit, that's authored and signed by Ms. Young, which is entirely inadequate. I'll refrain comment on the appropriateness, but the the adequacy of the evidence is multiple layers of hearsay. I'll note that this is the only evidence in the whole record on this. It's her own affidavit saying that plaintiff security expert has investigated the facts of the case, including interviewing several witnesses, and that a security manager had concerns about crime at the apartment complex. So we've got plaintiff's counsel talking to a unnamed security expert who then allegedly talks to a security manager, I think as they put it there. Multiple levels of hearsay in an affidavit that is not adequate evidence on summary judgment. Pure and simple. Now, high crime area, we can talk about that too. There's allegations that there are, I don't remember the number, 14 or 17 prior incidents of criminal conduct that occurred in the building that should give fair notice if we're talking about foreseeability. Not so. Again, we have evidentiary issues over and above the Siebert concerns, which Your Honor noted that has to be direct relation to the harm at issue, right? You can't just have a fight about a domestic dispute about cooking dinner or something like that if it has no relation to the harm actually incurred here, which was a vehicular homicide. An unfortunate event here. But if we're talking specifically as the evidentiary issues, look at the brief, and I would encourage the court, and I've already done so, to look at the actual evidence cited. For example, one of the multiple incidents on January 29th, this is an appellant's brief at 7. On January 29th, 2018, police were called to 715 Western due to an assault on a resident where a resident could hear a male jumping on a female. And that's specifically cited to Record of Appeal Volume 1 at 257. You can turn to that page, you get a single incident report from the police, Topeka Police, which is report calls in only. There's no actual report itself. And it notes that a Nancy Pregnell called the report in about this hearing somebody jump on somebody. And that when the officer arrives there, it made contact, the note is made contact with several apartments. Nobody knew a Nancy Pringle. This is why you don't rely on hearsay within hearsay for both summary judgment or evidentiary trial issues, right? You have multiple levels of hearsay here that do not establish any prior incidents, nor incidences that have direct relationship to the harm incurred here, right? So you fail under the Siebert test. As far as just the high crime area in general, I don't think that's sufficient to impose a different duty unless it's particularized to the property at issue. That's what Siebert stands for. You have to look at the totality of the circumstances. There was an underground parking garage where you had to come in out from public view. It was poorly lit, and there had been previous incidences at that specific location. You don't hotspot an entire downtown metro and say every property owner, proprietor, business manager now has a increased financial burden and tax to provide security within that just because there's crime generally in the vicinity. That's not something that we would want to impose upon anybody to dissuade businesses from doing, offering services and goods in a high crime area, so to speak. But this is specifically the issue here. That there's other evidence. So if you look at Siebert, and I'm running out of time, so I'll talk about foreseeability generally. You're talking about prior acts, right, that have to be on point. The only thing that even comes close is that there was a report, somebody was driving as an impaired or intoxicated driver. The report came from this location on October 17, 2017. But again, if you look at the record on appeal at 255, the report cited, the reporting person was there wanting to talk to the officer at that address. And they specifically called, saw the officer drive by and missed him, say, hey, I have something to show you. They didn't say where it happened. There was no indication as to where this event occurred. There's no facts, there's no evidentiary record to support that there is any type of prior acts, nor prior acts that would have a direct impact or relation to what the harm was incurred here. So for those reasons, I would note that the South v. McCarter case, I think, is controlling in this situation here. You have no foreseeability. The facts in that case were even more extreme, where you have specific knowledge alleged of acts of the perpetrator of the crime in that case, the boy who caused the fight previously, who had been known and been kicked off the premises previously for causing fights. This is not the case here. There's no relationship between my client and Miss Nolte. There's no evidence that really she even entered the property, to be perfectly honest. If you look at the police reports, it says that she stopped the girlfriend with whom she was called or from whom she was called on the street and talked to each other car v car, and then drove through the alleyway and then came back down and hit Ms. Kubler's car, which was parked right adjacent to the alleyway. So for those reasons, both the lack of control over this public space, the lack of foreseeability, the lack of evidence to support any type of foreseeability, and the idea that they're not a proprietor and the terms of the engagement are specified in the lease, we would ask that the summary judgment order be affirmed, unless the court has any other questions.
Questions? I can't remember.
Yeah.
What time of day did this happen?
7:19 p.m. on April.
Thank you.
Anything further?
No, thank you very
Thank
much.
you.
Counsel?
Thank you. Couple issues here, just to address. Robin Kubler was a tenant in her home, and a violent altercation occurred on her landlord's property. Property that the landlord absolutely had control over, the yard and the parking lot of the property. Her car was struck during that altercation, and she reasonably investigated the damage to her car. Counsel argues that in South, there was only a duty to the landlord in that case because of the lease agreement. However, if the landlord undertakes to provide security and then doesn't have sufficient security to address the issue, then they have a duty to provide that security. And here we know that they did have a security manager. You don't have a security manager simply to say we don't need to provide any security. That in and of itself shows that this property manager or this property owner was attempting to provide some degree of security to its property. This property owner definitely had control over its property outside and the parking lot. And Hammond is clear whether it's a retail business or a restaurant or a landlord who has control over that property, and the duty arises on the property and the breach occurs on the property just because the injury itself occurs just over the property line. The owner of the property is still liable. It'd be nonsensical to not apply Hammond simply because this was a landlord-tenant
So
situation.
let's just say a person was driving down the alley, not Miss Nolte, and struck and killed your client. Would the landlord still have duty?
If the person is just driving down the alley and there's no prior incidents of any issues, at the property line as a result of people driving. I mean, I could imagine a situation where driving in itself could be a problem, but if it's just a person driving down the public alleyway and hits someone, in the alleyway, then I don't think that there is a problem. The issue here is that this altercation occurred on the property and for a period of time, an extended period of time, and the damage to the car was caused on the property. It was simply, the alley is, the parking lot or the parking stalls are directly adjacent to this public alleyway. And so it's just, a step or two over that property line where she's hit by this car that was on this property to begin with, was not just driving through the alleyway.
Well, I thought counsel just said that she met her friend in the street and then she proceeded to go down the alleyway, and that's when your client was struck.
That's not my understanding of the record. My understanding of the record is that Ms. Nolte pulls into the parking spot and in the process of doing that hits Robin's car, who
And
is
then she left.
then then backs out when Robin comes, and before she drives away, Robin comes out to look at her car. And then Nolte drives down the alleyway and hits Robin, who's now standing at the back of her car, assessing the damage to it. That's my understanding of the record.
All right.
And the court, I just want to mention the court is, of course, required to consider the evidence in the light most favorable to the plaintiff, to Robin, which did not happen in this case. So
I have to ask you about your affidavit. This is a summary judgment case. Facts are crucial.
yes,
As you've just said, we look at the facts when we're interpreting them in the light, looking at them in the light most favorable to the defending party. Counsel talked about the inadequacies of the affidavit, and you don't need to go through those. I'm more concerned with the appropriateness of it. I've never seen an attorney's affidavit where there being a witness essentially in the case in support of a motion for summary judgment.
the affidavit was appropriate because included in the motion or in the opposition to the motion for summary judgment was the request to conduct more discovery. And so the affidavit, which is to be supported by an affidavit, as I recall the rule without having looked at that right away. And so plaintiff included in the response the issue that discovery hadn't completed yet. And there was more discovery to be done. There'd been a lot of investigation that had occurred on the plaintiff's part, including retaining an expert witness and interviewing individuals and witnesses. And so that was evidence that the plaintiff should have been allowed the opportunity to complete discovery and submit to the court. But the court denied that motion as well.
In the same, I guess, order when she
Yes.
ruled on summary judgment. Okay, thankful.
Yes.
That's helpful. Thank you.
All right. Thank you.
We'll take the matter under advisement and we'll render an opinion as quickly as time allows, generally within 60 days. Thank you, counsel.
Hey, please the court, Your Honor. James Latta, the Appellate Defender's Office, representing Travis Jeffrey. And may I please reserve 3 minutes for rebuttal?
You may. Counsel.
Ethan Zipsegler for the Kansas Attorney General's Office.
Thank you. Let me announce the case and then we can proceed. This is case number 128518, State of Kansas versus Travis Jordan Jeffrey. Counsel, you may proceed.
May it please the court. As your honors know, we're here about THC and its legality. As far as my reading of the Controlled Substance Act, Kansas Controlled Substance Act, THC is a unique substance where there are certain forms that have been accepted and are actually legal. So in other words, the Kansas legislature had made certain forms of THC a controlled substance and other forms are not a controlled substance. So starting with the criminal statute, it's what the state must prove is they must prove possession of any of the following controlled substances, and then it lists the statute for THC. When we go to that statute, we see that the legislature has made THC a controlled substance unless it's they have accepted all THC, not just certain forms, all THC in any of the following substances, which as applicable here, which includes industrial hemp and hemp products. So there is legal and illegal THC in Kansas according to the Controlled Substance Act. And so the state must prove that the defendant possessed the illegal form. In the briefing, and as I've argued a lot, marijuana, this comes up and the state is trying to analogize this to marijuana. This is very different from marijuana for the simple fact that the legislature, when you looked at the Controlled Substance Act, when it lists marijuana, it only lists marijuana. it provides no exceptions in the Controlled Substance Act for marijuana. And so if you read the State v. Brown case, the Kansas Supreme Court case, which came out after the briefing here, which is 321 Can 1, it talks about that's what the state must prove. It must prove that the defendant, or that was a distribution case, just to be clear, but it applies here because they talked about the state must prove that they had possession of a controlled substance, and the Kansas Controlled Substance Act just lists marijuana. So if the state proves that, they've proven possession of marijuana. In this case, though, what makes it different is the legislature has specifically accepted certain THC found in certain substances. So they're not even illegal. And so the state must prove that legality and illegality to prove that they actually possessed illegal THC.
But because it's an exception to the definition, why should the burden be on the state to prove that?
So it's very nuanced, but I'm trying to distinguish it from Brown, where the reason why is because all marijuana is a controlled substance. So once the state hits that burden, they don't have to go through and then try to prove that it's not, when in the definition of marijuana, it says marijuana does not include these things. So the state has already proven marijuana a controlled substance. As opposed to when the state presents evidence of THC, they have not yet proved that it's a controlled substance because not all THC is a controlled substance.
How do they prove it's marijuana?
They just, any evidence that says, I mean, my reading of the Kansas Supreme Court case is if an expert gets on there and says this tends to prove marijuana, that's enough. That's
But
sufficient.
is it proof by appearance or proof by testing to the level of THC in it?
For marijuana, it can be either one. The Kansas Supreme Court said THC can be sufficient proof of marijuana.
So back to Judge Gardner's question, who has the duty to show that it's less than 0.03 by weight? Is that an affirmative defense?
Sure.
As because it's an exception?
So in this case, the state has the burden, and that's because the state has to prove it's a controlled substance according to both the criminal statute 215706 and the Kansas Controlled Substance Act. That's what makes this different. Because only marijuana is listed in the Controlled Substance Act, when the state expert gets up there and says, we found THC, it's the active ingredient, it's marijuana, that they prove that it's a controlled substance. But certain forms of THC aren't a controlled substance. And I want to be clear that it's not like, if you look at the definition of marijuana, they're just saying these things aren't marijuana. Certain forms of THC are legal under the Controlled Substance Act, and then certain forms of THC are not illegal. It's just, if they're in industrial hemp, any THC found in industrial hemp is legal. It's legal to possess and it's legal to use, the way that Kansas has listed it. So it's that controlled substance that makes it different and why it's not an affirmative defense and why the state must prove it. Because under the statute, the state has the burden to prove it's a controlled substance.
Right, it's the substance, not the quantity of the substance, that determines whether it's subject to the Controlled Substances Act. I mean,
Right.
we've got the general statute 215706 that says it's unlawful for any person to possess any of these following controlled substances or analogs. And then you look at, it says, any substance designated in 654105H. And that statute lists THC as a Schedule I controlled substance. And then it provides exceptions for industrial hemp and hemp products, which apparently you're claiming your client might have fallen under and the state didn't prove they didn't fall under, correct?
Yes, ma'am.
But it clearly says that THC is a Schedule I controlled substance, regardless of the amount.
Sure, I understand. And my reading of the statute as a whole, they have actually accepted certain forms of THC. So the very first subsection of the whole statute says these following controlled substances. Then the heading for THC says cannabinoids, the following cannabinoids, unless specifically accepted. And then it has THC, and then it has the exceptions for THC. So they're not saying certain forms of THC are accepted. They're just saying THC found in industrial hemp is not a controlled substance. And my reading of the statute as a whole, they've actually carved out an exception. And so we get really hooked on this 0.3%, but the state could actually prove it also by just having an expert say this THC in this case didn't come from industrial hemp, didn't come from a hemp product. That would also be sufficient to prove the state's case.
Because they're linked. I mean, when you look at the definition of industrial hemp, I mean, it is something that is less than the 3%. Same thing with the hemp products. I mean, they're all tied to that.
Right. I mean, I think that'd be the easiest way for the state to prove it if they just text test the percent concentration.
Well, and I understand, I'm sorry, I didn't mean to cut.
No, go ahead.
Well, and I understand from the facts, the state chose not to test this for its level of THC.
That is correct, Your Honor.
And that is a test that's readily available for the state to utilize.
Yes, my reading of the record was the KBI, I believe it was, has made a blanket decision not to ever test that amount.
Is that because their position is that even trace amounts of THC, even those less than 3% are still illegal?
Based on the testimony, yes, but they misread the statutes because it is illegal. If you go to KSA 23908, it is illegal to sell, market, distribute, manufacture industrial hemp but it doesn't say use in there. It's just illegal to sell, manufacture, produce.
But that's because it's the Industrial Hemp Act. It's talking about producers and whether they have to get a license. It doesn't care about possession. Possession is dealt with in the Controlled Substances Act under the criminal law. So that this doesn't help you to talk about the fact that this doesn't say it's unlawful to possess it.
Right, but my point was is that nothing makes it illegal to possess because my position is also the Controlled Substances Act doesn't make it illegal to possess THC from industrial hemp or from a hemp product. They've only made it to sell. That was just my point there. But yeah, the Controlled Substances Act is where my position is that's where we win. Is because in the Controlled Substances Act itself, as opposed to marijuana, they carved out these exceptions and they said this THC from a hemp product or from industrial hemp is not a controlled substance. And so it's just legal to possess. And because the criminal statute makes it the state's burden to prove a controlled substance, that's why the state still must prove it. And we're not in the affirmative defense land or the land where the defense has to come back and disprove something. Unless there's any other questions from your honors, that's all I have for now.
Well, let me ask you this. When we're talking about the definition of hemp products, for example, says it means all products made from industrial hemp, including but not limited to cloth, cordage, fiber, food, fuel, paint, paper, particle board, plastics, seeds, seed meal, seed oil, etc. Final hemp products may contain a THC concentration of not more than 0.3%. So here we've got a pipe, apparently, that's intended for ingestion and trace amounts of THC in the pipe, correct?
Yes, Your Honor.
Okay. Does that meet the definition of hemp products?
Yes, it would. If the THC, as long as the THC is under 0.3%, and that's the point I'm getting at is we don't know what it is, and because it's the state's burden, that's why we should win.
But the fact it's less than 3% doesn't mean it's a hemp product. The hemp product means products made from hemp, including, like cloth, cordage, fiber, food, fuel, etc. How is it one of those when it's a trace amount of something in a pipe?
Sure, I'd have two responses. First, we don't know what's in the substance, what the substance is. So
Well, we know
because
other than, correct, go ahead, I'm sorry.
that's all right. So we don't know what the substance is, so it could be those things. And that gets me back to where I'm going to keep going is where the burden's on the state. So if it could be something, that should help us.
Is that a reasonable inference here?
I think so. I don't know what hemp products could be burned or not, and that's not an exhaustive list as well. And then it also could be industrial hemp. That would probably fit it even better, maybe. But then my other response would be that the KBI expert's testimony itself was that it could be hemp marijuana. So even the expert themselves testified in this case that perhaps this did come from hemp, is my interpretation of the testimony. So we actually have evidence that it could be. And so because of the burden, the heavy burden on the state, that should fall in our favor.
What about the circumstantial evidence? A pipe that's used for ingestion has THC. There's no allegation of marijuana. But is there circumstantial evidence that that was illegal THC?
My answer would be no, because the legislature has drawn a line at 0.3%. So I assume they did that because they think 0.31% can get you high. But 0.29% could just as easily get you high. They just drawn a arbitrary cutoff. But just because someone's using it for personal use does not give you circumstantial evidence that it's necessarily over that amount. And so even if someone wants to use it for personal use, the way the Kansas legislature has written the Controlled Substance Act is that that's okay. That's appropriate in Kansas. As long as it meets the definitions of industrial hemp or hemp product, you can use it for any reason at all, even to produce euphoria.
There's a Kansas Attorney General opinion from January of 2018 that states that your position is incorrect. Essentially, they say Kansas criminal laws regarding unlawful possession of controlled substances are found here. Says it's unlawful for any person to possess any substance designated in 65-4105H, Schedule 1. And Schedule 1 specifically lists THC as a substance included in Schedule 1. Criminal law doesn't quantify an amount. Trace amounts are okay. Therefore, it's unlawful to possess or sell products or substances containing any amount of THC. Are we bound to give some weight to the Attorney General's opinion in absence of any other controlling precedent here?
Well, obviously this court can give pretty much anything it wants persuasive authority if it wants to. My argument why it's not persuasive is the plain language of the statutes. That the Kansas Attorney General wants personal use to be illegal, and the Kansas legislature just didn't make it illegal. And it might have slipped through the cracks or for whatever reason. But in Kansas, it's actually illegal to use THC from industrial hemp or a hemp product for any reason whatsoever. There's nothing that makes it illegal, and therefore it's legal. So if there's no other questions, Your Honors.
Thank you.
Thank you.
Counsel?
I just do not believe that this is a good test case for this proposition for one very simple reason. There was evidence presented that this was not industrial hemp. The KBI lab technician was asked the specific question and answered that in industrial hemp, we would expect to see high levels of CBD, and we did not see them in the sample.
Now, wait, didn't she testify there were spikes?
I'm just reading from my own citations, so
Didn't the,
Your citations in your brief,
yes,
not from the record.
correct. So
So we would look to the record to
Correct.
verify that.
yes, but I mean, I have a record citation where that quote is from, so I'm sorry I don't have specific memory of that.
didn't the KBI expert testify that THC less than 3% is legal in this case?
I believe she said that. I
But
don't.
that's not your position.
Well, my position is that that's not what happened here. What happened was that there was a substance in a pipe that tested positive for THC. And there was a question, was it industrial hemp? And based on the circumstantial evidence that this is in a pipe, that it did not contain high levels of CBD, that it was used for consumption, all create sufficient evidence that it was unlawful THC. So I'm not getting into the question of whether or not it's 100% always unlawful to possess industrial hemp that has trace amounts of THC. I am just saying that in this case, the evidence was that this was unlawful THC.
But who has the burden to prove? Because we're only talking about THC. A lot of cases involve marijuana and THC in combination. So who has the burden to prove that the THC is above 0.03%?
Well, it's not that the THC is above 0.03%. It's that an industrial hemp product under the Industrial Hemp Act, as it's manufactured, can have THC up to that threshold. I haven't done research into the legal standards for the civil and the licensing. That is different than someone's ability to possess a substance that has THC in it. And those are two entirely separate statutes. So the question isn't, is the substance below 0.03%? It's, is it industrial hemp?
But industrial hemp defines, the very term says it's all parts and varieties of the plant, cannabis, whether growing or not, that contain a delta-9 THC concentration of not more than 0.3% on a dry weight basis. So that's how it defines industrial hemp.
But also used in products that are not meant for animal or human consumption. That is a part of that statute. So
Right. Which doesn't speak to possession. It says
No.
it's illegal to manufacture, produce.
right. So the question is, who has the burden of proving that they possessed unlawful THC? The state has the burden of proving that. But the question is, there's two questions. Is there sufficient evidence in the record to support that? Yes, because this was a substance that was possessed with knowledge of its consumptive effects. It did not contain high levels of CBD, and this person was not found with licensure to possess or to have industrial hemp products. So When we get through all of that, the evidence in the record, taken in the light most favorable to the state, is that this was unlawful THC. This is just not a particularly good case for this question because there is substantial supporting evidence that this was unlawful THC.
What is that evidence?
The fact that it was found in a pipe, the fact that there was no indicia that it was industrial hemp, the fact that it was used for consumption, and the fact that it didn't have high levels of CBD as would be expected by the KBI.
But we don't know that because they didn't test for it.
They didn't test the concentration.
Right.
Right, they didn't test concentration, but that is not the only way to determine if something is THC according to the expert at trial.
So there's really, under the evidence that was presented, there's no way to know whether this was illegal marijuana smoked or hemp smoked that left a residue of THC.
No, I do think there is evidence to support.
What is that?
Both the circumstantial evidence that it was used for consumption, which would show that it was a substance that was purchased for consumption, not purchased for an industrial
That's
use.
speculation, isn't it?
No, that's a reasonable assumption based on the evidence, but then we have the scientific evidence that industrial hemp would tend to show high levels of CBD, which this one didn't, which again is evidence in the record. So taken together, all of that is sufficient evidence that this was unlawful THC.
Because they tested for CBD, but not for THC.
They tested for both, I believe. If I read the testimony correctly. Oh, you mean quantities.
Percentage.
I,
Yeah, the percentage.
sorry.
I mean, we
I
know
was
that
so-
it
so-
had high levels
yes.
of CBD, correct?
No, I don't think it had high levels of CBD, if I was reading the testimony correctly. I may be mistaken on that, but
Well, the witness says, and this didn't have any CBD elements to it.
Oh, you're correct. It showed they thought it was low CBD, and that gave rise to the inference that
It
if it had
was
been,
not industrial hemp
Right.
because we would expect to see the
Higher.
CBD.
gotcha,
Yes.
gotcha.
That was where I was drawing that from. And I believe that that's evidence that it's not industrial hemp because that is what the expert said.
But traditional marijuana has CBD in it too.
I am not, so I am just basing this off of.
That's what the witness says.
Okay, yes. So
So why isn't this a good test case on whether or not it's the state's burden to prove that when it's only THC we're talking about, that it exceeds 0.03 when it's a test that can easily be ran by the KBI?
because I think in this case, you have other surrounding circumstantial evidence that supports the fact that it is unlawful THC. So I don't think that's a question we need to get to here. The remaining question is a scientific question that's just not a part of the record. I don't know if by testing something that is consumed in a pipe, it would register as lower levels, lower percentages of THC or not. I have not done that research, and that's not in the record on appeal, so I don't know how to support that position.
Well, the state sends out the Department of Agriculture or whoever manages the production of hemp to test it,
When it is,
in the process of managing that
Right.
production.
when it is in manufacture, yes.
All right, so why can't the KBI do that in the process of a criminal prosecution?
Well, again, and this is what I'm saying is I don't know how, if it would even matter when we're talking about residue. Like, I don't know if the residue will continue to have a THC percentage more than 0.03% after it's been,
Consumed.
well, ignited in this case. So but that is not in the record. I don't know the answer to that. So I can't say why the KBI, if there are other reasons. The KBI testified that they don't test this because it's their position that all THC is illegal, but I also don't know if there are other issues because that wasn't before the court at the time.
You may proceed.
I think the question of whether it's a affirmative defense is, obviously, it's been the state's position in other cases that claims that something is an excluded substance is an affirmative defense. Unfortunately, we still don't have an answer from the Supreme Court on whether it is or not. I believe there is some conflicting Court of Appeals authority that has said it's not an affirmative defense and some that has said it is. I don't have those citations, but I've dealt with this in another case. So there have been some conflicts as to whether or not it is a affirmative defense or if it is something that the state primarily has to prove that it's not one of the excluded things. I tend to believe that industrial hemp is a separate substance than THC. And if the defense is this was industrial hemp, the jury just finds not guilty on THC. They don't need to be independently instructed that industrial hemp is legal. They are being asked to determine if the person possessed unlawful THC, and if there is evidence that it is not THC, the jury would just acquit. But there wasn't evidence of that in this case.
So why wasn't a jury instruction to the jury to determine that the THC was above 0.03% was something they should consider?
Well, but that's not the standard. It's that it's industrial hemp, which does not mean that a substance with a THC percentage under 0.03 wouldn't still be unlawful. It has to be all things real. It has to be industrial hemp. In addition to that, industrial hemp has to have a THC level under 0.03%. But that doesn't mean that there aren't substances that would have the same THC concentration that aren't just THC, because they aren't one of the substances included in the Industrial Hemp Act.
That really confuses me
Yeah, I
because
don't get that argument.
the definition of industrial hemp is all varieties of the cannabis plant, whether growing or not, that contain 0.03 THC of the Delta 9. That's the definition of industrial hemp. It's not hemp products definition, but that is industrial hemp definition. So
Then I was just
confused.
mistaken on that.
Okay. And then, it does go ahead in the Industrial Hemp Act and says it's unlawful for the following hemp products to be manufactured, marketed, sold, et cetera. And it talks about cigarettes, cigars, chew dip, or other smokeless material, teas containing industrial hemp, liquid solids, gases containing them, and any other hemp product intended for human or animal consumption containing any ingredient derived from industrial hemp that's prohibited.
Yes.
So, I mean, they're saying even in the Industrial Hemp Act that none of this is intended for human consumption.
Correct.
So does that help you at all with the circumstantial evidence? I mean,
I believe that does, because it limits, there aren't readily available sources of consumable industrial hemp. So by extension, it is a logical conclusion based on the evidence that a substance which is consumed is not industrial hemp.
This is an interesting question as to who has the burden. When there is, because we all know people consume things that they're not intended to consume. The question is whether that consumption is illegal. And if they get a hold of industrial hemp and consume it, that's not necessarily illegal.
So
I don't find in the statutes where that's defined to be illegal.
I think in this case in particular, we have other evidence that establishes what the substance is, and that makes it not a great test case for who has the burden, because the state just would have met its burden regardless. I think secondarily, if we're talking about who has the burden, I think when we talk about exceptions, those are affirmative defenses. And there has to be some evidence that a person is claiming that, and then the state has a burden of overcoming that claim, but that wasn't presented here. There isn't a claim that this was industrial hemp. There was a question asked of the expert, and the expert's answer was, I don't believe that this is industrial hemp. So or the expert's answer was to provide reasons why. In this case, they concluded that it was THC.
I think the expert said, the question was, you just don't extrapolate if that means it's hemp marijuana or CBD marijuana. The answer was, there's really no way to know. So the expert didn't know.
I believe the expert gave differing testimony that gave different answers, but again, the standard is in a light most favorable to the state, and we have a statement that in industrial hemp, we would expect to see.
And I just read
CBD.
from volume 10, page 231.
Correct.
All right. Anything further? Thank you very much. It's an interesting question. Counsel?
May it please the court. I just want to clarify that my interpretation of the expert's testimony is that she didn't know about CBD. And I would refer this court to volume 10, page 230. This is during cross-examination where the defense attorney specifically says, I want to clarify. And the question is, so you're saying there was you're saying the presence of both CBD, Delta 8 and Delta 9. And she responds, no, I don't know about CBD. And so if you read all of her testimony, to me, it was she didn't know whether CBD was present. She said she couldn't rule it out. And so that any circumstantial evidence should be disregarded from one witness who's unsure to say this was some type of illegal THC. Unless there's any other questions, that was all I had.
Thank you.
Thank you, Your Honors.
As I previously said, we'll take the matter under advisement and issue an opinion as quickly as time allows. Thank you. Hopefully within 60 days. Have a great day.